Okay, we're now recording. Good morning, and today is April the 29th, and we are convening for a public deliberation. It is 9 a.m. before the Baltimore County Board of Appeals in the matter of Gemcraft Homes, Inc., case number CBA 25-007 for property located at Armstead Road, lots E and F, shown on the second revised plat of Cedar Crest, Baltimore, Maryland 21219. And this is regarding an appeal of a denial of a building permit from a letter dated September 27, 2024, issued by the Director of PAI. We convened a hearing on March 20th, 2025, which was held in person. And the panelists were me, Shram Bernardi, as chair, and Joseph Evans and William Paulshaw. And wherein the petitioner applied for a building permit to construct a single-family dwelling on a parcel described previously that abuts a paper road shared by two other property owners. And I saw that we had three issues, and I'll state them, and then please let me know if I have left something out or if there needs to be clarification of how I was framing what was before us. And so the first I had was whether it was regarding the county's motion to dismiss and whether the motion should be granted based on a procedural issue of whether or not the appeal is yet ripe and that the county had not issued a determination on the petitioner's permit request. And another related to the motion to dismiss, the county was arguing that the motion should be granted on the basis that neither the county director of PAI nor the Board of Appeals acting in the position of the director of PAI has the authority to hear the case on the merits. Because doing so requires a determination of real property law that does not rest with this board, but with the Circuit Court of Baltimore County. And then if we were not to agree on either of those, then we would then need to deliberate on the merits. Do you agree with proceeding in that order?
That's fine with me, sure.
Also,
Yeah.
Thank you both. So first on the issue of ripeness, and unless someone wants to go, I could begin that discussion. So
Okay.
how I agree with the county in that the letter was not a final determination of the county. They were requesting additional information. And I understand the petitioner's position that they provided the information and that they provided the information. They feel that the county in effect was denying the request. No, I do feel that the county can, in their letters, be, I guess, more clear. For example, if they felt that they had information and that information was insufficient, that maybe the letter should say, if you don't provide additional information or if we don't receive something in a period of time, say a reasonable time of 30 days, then they would issue a denial of the permit. But I mean, that's not required here. And my concern is that if we grant or see that this letter that was not definitive, if we took that as a final determination, we could have just parties circumventing that part of the administrative process and just want to get before the board, before the county is able to consider everything that is before them and making a determination. And would love to hear from the both of you.
Yeah, I feel the same way on your views, Sharon, Madam Chair. And it's hard to rule with no determination. You know, they're just asked in that letter more information. And as slow and aggravating as county issues are, um, it's a tough process, but it's hard for us to rule without seeing it being denied. I think their letter needs to be a little more clear in timing, but in the same process, I think it needs, I feel the same way you do, Chair. Madam Chair.
I flip back and forth, frankly. The letter outlines a number of types of information that the director believes would be appropriate to resolve the question, all of which are subsumed in the notion that there's an implied easement. All of those issues fade away if there's an implied easement. And the director then goes on to say you have an implied easement, but we don't have the authority to make such a ruling. That's what the director says in his letter. I don't have the authority to make that determination. You have to go to circuit court. So there must be a sense of, and then if we were to say, well, he hasn't decided the issue, that it seems to me, and I'm sympathetic with the frustration that Gemcraft must feel under those circumstances, because what more, it says to itself, what more can it do? Okay, we say we have an implied easement. You say you want more information. We've given you all the information, and your letter is tantamount to a denial of our building permit. It's a de facto denial. That would be Gemcraft's position. And I'm not sympathetic to that position. What is it supposed to do? We're supposed to remand it so that the director can take his letter and add one sentence to it. Unless and until any of this information is supplied, this constitutes a denial of your building permit. It could be seen as form over substance. Mm-hmm. So that's what half of me thinks. Okay. The other half of me thinks that the letter just isn't a denial by its terms. They want us to imply an easement, and they want us to imply a denial. It's pretty darn, the whole thing is pretty darn fuzzy in that regard. And so I think I would ultimately I guess I'm probably 51-49 on the side of it's not a denial, but I'm not overjoyed with that conclusion. But that is kind of where I come out, sort of, as I've said, for the reasons that I've said. But I would like, for my own purposes anyway, or for my own satisfaction. I would like us to not stop there,
Agreed.
okay? Because I'd like to discuss the other issues further, because I think this thing needs to be, this situation needs to be put on the right track. Otherwise, it's going to stumble around in the netherworld for a long time. And I think it would be useful for us to try and avoid that result. Okay, so that's where I am.
And I agree it would be like inefficient to just rule on ripeness and then procedurally the department potentially issues a denial and then they have to go through this process to order, to be heard on the other matters. So, so let's
Right,
go.
right. We would be right back where we are in a month. I mean, they would take another appeal from a denial letter, and then we'd be right back here. And, more time is being wasted, more money is being spent, and more effort is being expended. Right.
So I agree. We can then move into the discussion on whether or not the director has the authority and Ariel, whether or not the board has the authority to hear this matter on the implied easement. And Joe, you started that discussion if you wanted to continue.
Right. So if we assume for the moment that the permit was denied, okay, let's just assume the permit was denied and it was denied because the director doesn't have the authority to make the decision that the petitioner wants it to make. Then in my view, the director's decision is correct. The director doesn't have that authority. And we don't have any authority that goes beyond the authority that the director has. I mean, we don't have any superpower. We just, all we can do is decide whether the director was correct or not. And if he wasn't correct, was he not correct for a reason that we can remedy? But we can't remedy. I mean, we can't find that there's an implied easement. I mean, we just can't make that decision. This is way beyond our authority, way beyond the director's authority. And, it is, I mean, these other people that have an interest in this land, they have to be involved. I mean, whether it's cumbersome for them, whether they want to be involved. I mean, if they don't want to be involved, they can just default. But we don't know what their interests are. They're not represented. We haven't heard their voice. We're at an utter loss here to make such a dramatic ruling. So the director can't do it and we can't do it. So if this constituted a denial letter, then I would rule, in terms of the merits of the appeal, I would rule in favor of the director or in favor of the county, because we can't do anything, because he's correct. He doesn't have the authority. And so, I mean, if it comes back in a month, that's how I would rule, in a month, based on these circumstances. The only single thing that Gemcraft can do here is file an action for a declaratory judgment or something like that. I don't know enough law in this whole regard to know exactly what you file, but file, let's just say it's a motion, a petition for a declaratory judgment that they have an implied easement, and then they serve everyone, and then the court decides it, and if they do, they do, and if they don't, they don't. Probably they do. I suspect they do, but I sure don't know enough to know whether they do. And then they can go to the director, and then they can say, look, we have an implied easement, so grant us our building permit. And I can't help but believe the director would do so in a heartbeat. So I don't know why this fight is going in the direction it's going. I don't understand that. honestly. I don't understand it. I'm not the brightest guy in the world, and this is way out of my comfort range. But I don't understand this dispute at all. Shouldn't be here. Should be in circuit court.
And I believe in the same process. I'm glad we had this discussion a little fun. And the due process of property law, you have to get all parties involved, and we can't ignore that. And it's not a place for this court. And I feel the same way, circuit court. And it's a shame. It has to go that way. And Baltimore County has a slow process and aggravating process at times. But due process for all properties owners is key at this point. And so I'm glad, Joe, I heard the whole process of it for everyone. And there are 3 steps in that letter that should say that can be remedied. You know, the court's property agreement with neighbors, or the road closure and opening. So there is some avenues, but I agree with Joe at this point. Circuit court, if they take that option, is, you know, that's one of 3 options they have. So I do agree with that, Joe.
Mm.
I agree with both of you. I do know what petitioners had referenced, and it was the Stewart case in St. Mary's County, and said that, you know, that their similar board was able to make a determination that involved as a matter of property law, but they, in that case, they even stated that the permit application had met all the regulatory requirements, except for, I think it was the environmental impact analysis was required. And I think that's distinguishable from this here, because I don't feel that they have satisfied all the requirements. I don't even know what all those requirements would be at this point in time. So I don't think that case was on point here, but felt that.
Yeah, I didn't think that case was appropriate actually at all. I thought it was quite not on point. I mean, it seemed to me that it didn't have to do with the question of ownership of real property. It had to do with regulatory compliance, and we're talking here about ownership. An easement is an ownership interest. I mean, it's not a regulatory interest. I maybe I'm wrong, but I thought that case was not convincing in the slightest, actually.
I agree with you, and just felt that since they referenced it, we
Yeah.
should
Right.
mention in the deliberation. But I agree with both of you that, I mean, any proceeding on the merits would require the other property owners to have an opportunity to be heard, and to make any type of determination without hearing their interests would definitely be a violation of their due process. So would most definitely grant the motion to dismiss on these grounds, even if we couldn't, you know, reach an agreement on the ripeness issue.
Well, yeah. So it would be like we grant the motion to dismiss on the fact that it was on ripeness, and in the alternative, we rule for the county and on the merits of the appeal, because the county doesn't have the director didn't have the authority to declare there to be a private easement. And then it really doesn't matter, because I mean there's no way in which Gemcraft is foreclosed from seeking a second building permit once it has a ruling from the circuit court. I mean, this doesn't have any negative effect on the, its rights or anything. All it has to do is go to circuit court. Once it does that, it can go and apply for a permit. If it feels so strongly that, it gets a denial, an explicit denial letter, and then appeals back to us, and we'll deal with it again, and then they can appeal to circuit court. But if they appeal our decision to circuit court, the circuit court doesn't have any authority in this procedural process to grant an implied easement either, because doesn't involve the other landowners, and the issues aren't before it. So, I mean, there's no route, it seems to me. There's no route to resolution here that ignores filing a separate action in circuit court. So that's my view, for what it's worth. I'm in bad mood today, so.
May not be in the same mood, but we all concur on the outcome, and wish the parties could have a conversation and work out a way for them to proceed and not have undue delay.
Right.
Well, thank you both, and thank the parties for their professionalism and preparation of the closing memos, and we will issue our determination in order. And this concludes the deliberation.
Thank you, Madam Chair. Appreciate it.